Great. Did you guys have some fun getting to know each other?
Mm-hmm.
Always.
Always. Nice. All right. And this is my favorite time before we go further. Let's show us big 2 thumbs up. I'm gonna get a screenshot.
Oh, hold on.
All right. Everybody turn the camera on. Big thumbs up. Unless
There you
you're
go, man.
driving. I don't want you to do that if you're driving. Other than that, just show us big thumbs up. I go 3, 2, 1. All right. Great. That looks beautiful. All right, Nico, who do we have today?
Okay, guys, thank you all so much for being here. I'm excited. We have Miss Kim Lisa Taylor. So Kim Lisa Taylor is the founder of Syndication Attorneys, PLLC, a boutique corporate securities law firm that helps clients nationwide with their federal real estate securities offerings. Kim and other members of the Syndication Attorneys team focus on helping small business owners and developers structure and convey their investment opportunities in a way that will attract private investors, both domestic and foreign. They teach their clients how to use securities laws effectively and provide them the tools and resources they need to achieve their business goals legally. More than a law firm, Syndication Attorneys PLLC helps entrepreneurs create successful investment companies. Now, licensed as an attorney in California since 2002, Kim has made corporate securities law her primary focus since 2008. She has been licensed as an attorney in Florida since 2012. Kim has written more than 100 securities offerings and numerous joint venture agreements for entrepreneurs raising money, $50,000 to $100,000 or more at a time from private investors, whether from within their own network of family and friends, through crowdfunding, or on the internet, or from private equity joint venture partners. Kim Lisa Taylor, welcome.
Hey, thank you for having me. Hey, I need to update that bio. It's actually about over 400 securities offerings now that I've been the responsible securities attorney for. So we're going great guns. So let me go ahead and start my presentation. You guys tell me are you seeing the right screen? Or are you seeing the presenter screen?
We're not seeing a screen yet. And
oh, let me share. Oh, wait, hold on.
And guys, if you have questions throughout, please type it, and Kim will do her best to get to those questions, and we can also help call out those questions. So please feel free. She is an open book and a wealth of knowledge.
Okay, how about now?
Yep.
Are you seeing the correct screen, or are you seeing the presenter screen?
We're seeing the presenter's screen.
I need to swap screens somehow. I know there's a way. There we go. How about now?
Yes.
Perfect. Okay. All right. So this is where we reveal the capital raising secrets and teach you how to legally raise capital for real estate investments. So in my opinion, the way to raise capital most effectively is to get rid of the fear. And the way that you get rid of the fear is that you learn the subject matter in and out. And I don't want you to become an attorney, but if you become familiar with the rules that you have to live by, then you're going to have a lot less fear and a lot less uncertainty. My disclaimer, this is for information only. There's no guarantees. The results depend on you. This is not legal advice, and we don't have an attorney-client relationship, but we would love to. So if you want to contact our firm, you can go to our website, syndicationattorneys.com, and schedule an appointment with one of our staff. I am a #1 Amazon best-selling author, wrote the book, How to Legally Raise Private Money, wrote it in plain English. It's the same way I speak. It's the same way we've written our legal documents so that everybody can understand and become more successful in what they're doing. I did found Syndication Attorneys PLLC back in 2016. Prior to that, I was a partner in a securities law firm in California. I am a syndicator. My husband and I had a 27-unit apartment complex for a while. We have had other investment properties in the past. We sold our apartment complex in 2019 after we'd owned it for 9 years. And we did okay with it, but my husband decided he didn't like it and didn't want to do it anymore, so he retired. I used to be a property manager. I actually managed a 264-unit multifamily property in Southern California for a number of years, and that was quite an interesting experience. And I'm a real estate broker, and then I'm also gone through a certified capital raising course through Richard Wilson's club. So I've been the responsible attorney for hundreds of securities offerings, allowing people to raise over $1 billion and to buy over $3 billion in real estate. So let's talk about what you need to know to legally raise private money. It's really like learning to drive. Okay, everybody thinks it's super complicated, but it's not. If you're learning to drive, you need to learn how to use the road sign so you can get from where you want to go safely. You need to learn how to navigate, beyond just the GPS. Sometimes you might actually have to look up a map, and you need to learn how to operate the vehicle. So there's really 3 parts to syndication. So the first part is how to comply with securities laws. Second is how to split money with investors. And the third is how to legally market your offering. So how to comply with securities laws. This all arose from the Securities Act of 1933, which defined what things constitute securities. So if you look at the Securities Act of 1933, there's about a half a page of definitions. There are all these different terms and phrases, but there's a couple of them that pertain to what we're doing, and those are promissory notes and also investment contracts. We'll talk about what investment contracts are in a minute. But the Securities Act of 1933 also stated that you have to disclose all material facts so that investors can make informed consent. And this happened because prior to the stock market crash, there were a whole lot of people that were, snake oil salesmen selling, swampland in Florida, Brooklyn Bridge, all that stuff. So the SEC made it a federal crime or a federal requirement that you had to disclose all these material facts, and that there's penalties for non-compliance and penalties for fraud. Prior to the Securities Act of 1933, the states had individual anti-fraud laws so that somebody could defraud investors in one state, skip over to another state and escape prosecution. So that's why the federal laws were created, was to avoid that situation and make it a federal crime. So what the Securities Act of 1933 said was that the offer or sale of securities must be registered or exempt from registration. So an offer, what is an offer? It's anytime you offer somebody something in exchange for money. Okay, so it doesn't have to be securities, but there's lots of other contexts. But in our context, you're offering somebody a promissory note in exchange for their money, or you're offering them to sign into your operating agreement for your LLC so they can buy some of the interests in your company. You're giving them the piece of paper, which is the operating agreement, in exchange for their money, and then you're offering them something in return for that. So we've talked about that it's promissory notes or security, or everybody I think knows what a promissory note is. A lot of people don't think promissory notes are securities, but they are. And then the investment contracts, this comes into play whenever you're selling interest in a company. So here are the elements that have to be present for you to be selling investment contracts. One is an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. So if you're the one that found the deal, you're the one that's conducting the due diligence on the deal, and you're out there trying to find investors for the deal, you are the promoter, and all those investors are going to passively invest with you in this common enterprise, which is the property, and they're expecting you to generate profits on their behalf. Then you're selling securities. So you're selling investment contracts. When you're selling investment contracts, you're selling securities. So examples: interest in an LLC, limited partnership interest, corporate shares or stock, or any kind of a passive investment. So what is syndication? So according to Black's dictionary, which is a law dictionary that every lawyer knows about, it's organizing a group for a common purpose to promote a common interest or to carry out a particular business transaction. So you can form syndicates to do a lot of things. You could buy a plane, you could buy a yacht, you can buy, a golf course, you can buy any kind of real estate, but it doesn't just have to be real estate. Also, people who are raising money for their startups, they're following these exact same laws that we're going to teach you tonight. If they're raising money from private investors. So if they're raising money from venture capitalists, that's a little different. But if they're raising money from their family, friends, and acquaintances, or advertising for investors, then they're following these exact same rules we're teaching you tonight. Okay, so what's the difference between syndication and a joint venture? Well, in a joint venture, you have an investment of money in a common enterprise with an expectation of profits, but the investors are responsible for generating their own profits. They have to all be actively involved. So the way that we would do that is when you create an LLC, you have the ability to create an LLC as a manager managed LLC, where the manager makes all the day-to-day operational decisions and generates the profits for the members. Or you can have a member managed LLC where all of the members are considered to be managing members. So that's the typical entity choice for a joint venture, is a member managed LLC. But in order for it not to be considered an investment contract, the investors have to be actively involved in generating their own profits. My experience is that more than 5 people in a joint venture is a disaster. So and there's joint ventures used, to buy real estate directly. There's joint ventures used to create the management entity that manages a syndicate. So anytime there's more than 5, I've just seen those go wrong. Worst case scenario ended in litigation immediately after closing on the property. So, think about that when you're inviting people into the management team. If you're going to syndicate, is don't put too many people in there. There's not enough jobs for everybody. And then you're just going to get too many dissenting opinions. So this is the problem with joint ventures, is everybody has their own idea of where everything should go, and nobody ends up going where they need to go. So there are 3 types of securities offerings. There's registered. So registered offering, remember in the beginning, we said that the Securities Act of 1933 said that an offering had to be registered or exempt from registration. So registered means IPO, means going public, taking your company public, initial public offering. All those things connote a registered offering. So this just means that you're actually applying to securities regulators to be able to sell your offering to the general public, and that you go through a vetting process with them. They go back and forth with you. You're going to submit a huge pile of paperwork. It's going to take months and months to get it done. And eventually, after you've answered all their questions and revised your documents to what they thought you needed to say, then you can become a public company. And then at that point, you have all of these ongoing reporting obligations. And, you might occasionally hear of Elon Musk tweets something out and the SEC goes, ballistic because he did something that influenced investors or something like that. So you're now subject to all this regulatory oversight and scrutiny. Well, nobody has time to do that for a real estate offering, right? You got, max, you've got 90 or 120 days, you got to get that property closed. And so the alternative to registration is you have to qualify for an exemption from registration. There is a 3rd type of securities offerings, and those are illegal offerings. So those are people who haven't registered. They're not following the rules of an exemption. They don't even know that exemptions exist. They're just out raising money. Okay, so who doesn't follow securities laws? People that don't know, people that don't care, people who are in denial. And you'd be surprised how many times I have people contact me that are, just out willy-nilly raising money, and and I would tell them, well, you need to do this, or you need to do that. And they would come back and say, oh, I just do limited partnerships. I've never done that. That's just never going to work. I'm not ever going to go through all that. So they're just in denial. The thing to realize about investors in general and all people in this world is that some people can't be helped. And so if you find them, just, if they're family members, you just love them anyway, but try not to help them. I've learned that with my own family, right? There are the other people that don't follow securities laws. There's a lot of people that are in jail for not following securities laws. So, this is serious business. You can go to jail if you don't follow securities laws. Bernie Madoff, you've heard of Ponzi schemes. There's quite a few people that have gone to jail for those kinds of activities. So when do you need to follow securities laws? When you're raising money from private investors. And when I'm talking about private investors, I'm not talking about your hard money lenders that show up at your real estate investment association meeting saying, hey, we've got money, we're trying to place it. I'm talking about your aunts, uncles, brothers, family members, people, other attendees at local real estate association meetings, neighbors, those kinds of people. All right. Also, when you're selling interest in a company to passive investors, or when you're repeatedly borrowing private money. So if you're in a business where your business depends on repeatedly borrowing private money from these private investors, then you are selling securities and you do have to comply with these securities laws. If you're just doing a one-off loan from somebody, or if you're borrowing from an institutional lender, somebody holding themselves out to be a lender, then you don't need to worry about that. They have their own rules they have to comply with. But if you're repeatedly borrowing money from your friends and family and people that you meet, then you probably need to think about securities compliance. So what does it mean? What does it mean to follow securities laws? So either you register your offering or you choose an exemption, and then you have to document compliance. So most of you, all of you are going to be operating under the exemption rules if you're going to be using money from private investors. And then these exemptions are self-executing. That means that you have to document how you complied with the rule. So think of this like a tax deduction, right? When you're filling out your tax return, you can check a box and say, yes, I'm entitled to this deduction, which is all fine. And you get the benefit of that deduction unless the IRS wants to audit you. And then if they do audit you, then they show up at your house and they're like, okay, show me all the documentation you have to prove why you're entitled to this exemption. And if you don't have that documentation, they're going to take away that deduction, and they're going to make you pay the tax, and they're also going to make you pay some penalties and interest. So exemptions for securities are similar in that you have to document how you complied if you were ever approached by a regulator who said, I heard you're raising money, show me all the documentation related to your offering. What they're looking for is to make sure that you have the right documents, that you followed the rules, and that you have some kind of documentation to show how you followed those rules. So if you have a whole big box of files that you can say, here you go, Mr. Regulator, then you're probably going to be in pretty good shape. The people that are not in good shape are the people that are like, what are they talking about? And they have nothing. Okay, so that's the people that are in trouble. All right, so let's talk about what these securities exemptions are. This is probably the most important part of the presentation. So usually exemptions will, they could limit the amount of money that you could raise, could limit the number of investors that you can have, or the number of investors with certain financial qualifications. They will maybe impose some qualifications on the investors, saying they have to meet certain financial criteria before they're allowed to invest in private offerings. They may not allow any advertising, or maybe very limited advertising that's not very sexy. They all require that you disclose the risks, because remember in the beginning, we said that when you're selling securities, you always have to disclose all the risks and all the material facts that would allow an investor to make informed consent. And those risks are pertaining to the property, taxes, all the different things that could affect someone's decision to invest that they might not be aware of, because you could, there's just a multitude of things. And then there's also securities notices that need to be filed. And so there are both state and federal exemptions. So the federal securities regulator is the Securities and Exchange Commission, but every state has its own securities division. So it's more likely that if there's an enforcement action or a complaint filed against you, it's going to happen at the state level. As near as I can tell, the SEC doesn't really prosecute anybody unless they've stole like $15 million. It seems like that's their threshold. And once you get to that number, it seems like then they pay attention because it's newsworthy, I guess. But the state regulators will, they'll send somebody out because of, $100,000 investment. And the thing about the state regulators is that they have an organization that governs all of them, and they get on weekly phone calls. And if one state has found somebody violating securities laws in their state, then they'll let everybody else know, and they'll all start digging around to see if you did it in their state too. And you could end up with, several state enforcement actions against you. So you don't want to be in that position. And the way to not be in that position is to make sure that you document how you are following the rules of the exemption, and you make that available to regulators if they ask you for it. If you ever do get a letter from a securities regulator, you absolutely should hire counsel to help you respond to that. So just, and we've done that before, and we've actually responded on behalf of people, and the whole thing has just gone away because we were able to show them that, hey, here's how they complied. Here's all their documents. They did everything right. Okay, that's good. All right. So we need to know a little bit about investor qualifications because you're going to hear about that when we start talking about the specifics of these exemptions. An accredited investor is somebody who has over $1 million net worth or $1 million or more net worth, excluding equity in their primary residence. Or they have $200,000 a year income if they're single, or $300,000 a year income if they're a couple or a married equivalent. And so that was recently a relaxed standard last year that came into being that you didn't have to be married, but if you're cohabitating or you're a married equivalent couple, then you could still claim the couple's income. There are some other definitions that pertain to individuals. There's actually 12 definitions of accredited investors. These are the two, the net worth and the income requirements that are most often encountered by our clients. But they added a few new ones last year. There's people with certain securities licenses can now qualify as accredited, and then this quasi-married. And then also they added that something called a knowledgeable employee of a fund. So if you have a knowledgeable employee that wants to invest in your fund, they can be accredited by definition. But one that's always been there is any member of the management team, any director, officer, or someone involved in management of the offering itself is by definition accredited. So even though you might not meet the financial requirements, you can invest in your own deals, even if you don't meet this requirement. So here's some of these rules of these exemptions. And these are just the first two, Regulation D, Rule 506. This is the most common exemption that there is. I showed the Florida private offerings and the California private offerings just because that happens to be where I'm licensed, but also because you can see that they're quite similar, actually. So the state securities laws sometimes mirror the federal laws, but sometimes they're a little less onerous. I was just looking at a Texas securities exemption yesterday that allowed, as long as you knew someone very well, and then you gave them a disclosure document, you could have up to 35 people in a deal, and as long as they were all from Texas. So then there wasn't a lot of the same filing requirements. So the ones we want to talk about are Regulation D, Rule 506B. There are about 25,000 securities offerings filed with the SEC every year. And the bulk of them, 90% or more of them, are Regulation D, Rule 506B. This is the original rule. It came out in about mid-1980s. The reason that it even came out is before that, every offering to investors had to be registered. And people started complaining and saying, hey, I want to invest with my buddy from the country club. Why can't I do that? I know what I'm doing. I'm sophisticated enough to do this. So the SEC relented and said, okay, for these private offerings where you're just offering it to people that you know extremely well, we will allow you to do these private offerings and you don't have to register them. And so that's what this rule came out of. So there's no dollar limit. You can raise, billions of dollars. In fact, giant hedge funds use this rule. You cannot do any general advertising or solicitation. And the way you prove that is to be able to prove that you had a pre-existing substantive relationship with each investor. And so that's part of what you have to document is how did you have that relationship with that person, and what information did you know about them before you made the offer. You can have an unlimited number of accredited investors and up to 35 non-accredited but sophisticated investors. You must file a notice with the SEC. It's called a Form D, and then the states where your investors claim residency also require that you file notices there, and they all have fees that they want to collect associated with those notices. And you have 15 days from when the investors' funds become irrevocably contractually committed. And when that happens is a little bit debatable. It certainly happens when you use their money, but it could even happen before that, depending on whether your documents, what your documents say. So you want to make sure that you understand when that irrevocable contractual commitment occurs so that you can do those filings in time. And then if you have any non-accredited investors at all, and you're doing a Reg D Rule 506B offering, then you're required to have a private placement memorandum. You're not required to have a private placement memorandum if all of the investors are accredited. But we recommend one if there's more than 4 or 5 investors in your deal, just to protect you, because the private placement memorandum does protect you. So the other rule is Regulation D, Rule 506C. Okay, this came out of the Jobs Act. And so this is where everybody started complaining, hey, it's so hard to be able to make relationships with all these people, and we should be able to advertise. This is the world of social media. Why can't we advertise? And the SEC relented and said, well, okay, as long as the only people that invest with you are verified accredited investors, then we'll allow you to advertise because those people are rich and smart enough to take care of themselves. And so a lot of people use Reg D Rule 506C, but all of our clients start with Reg D Rule 506B, build a track record with people that who don't care so much about your track record, and then go out and start advertising after you've gotten all those people invested with you and you have a sufficient track record that you can survive the question a stranger is going to ask you, which is, how many of these have you done before? Okay, so if you can't answer that question, a stranger won't invest with you. So if you don't have that kind of experience, either you need to wait till you get it, or you need to bring someone on your team that has it. Okay, so what defines this relationship? Pre-existing means it predates the offering, right? So it predates the time that you had. Technically, it predates the time that your offering was current or contemplated. So current means you have offering documents in hand. Contemplated means you've hired your attorney, they're drafting the documents for you, and you've conducted sufficient due diligence to know you're going to buy the deal. I don't think LOIs are not contemplated offers because so many of them fall through. And even purchase agreements, it could be argued, are not necessarily a contemplated offering until you've done enough due diligence to know you're going to go forward. What is a substantive relationship? This is the one that's the hardest for everybody to understand. It means that you have to determine the investor's suitability to be in your deal before you make an offer to invest to them. There is an article on our website. If you go to syndicationattorneys.com and go into the library, select articles, it's the very first one that comes up, and it's called How Do I Create a Substantive Relationship? That article explains what the SEC says is necessary to have that substantive relationship, and it even has some example questions. So the rule is, for 506B offerings, you have to have developed the substantive relationship before you made an offer, which means you had to have a conversation with these prospective investors about their finances and their investing goals. And so a lot of people don't understand that. They believe that, oh, they're in my database. Oh, I've known, my neighbor's been next to me for 30 years. Well, you don't know about their finances unless you've actually had a conversation with them. Or maybe if you just know that this guy, makes more money than imaginable. He's the president of some huge company or something, right? You can probably presume they're credited at that point. All right. So how do you split money with investors? So that's the second thing we need to learn. How do we do this? So here's a typical joint venture. We talked about the member managed LLC, where all the members are considered managing members. And so this joint venture could be used to take direct title to real estate, or it could be used as the management of a syndicate. So this is a typical specified offering structure. So there's different types of securities offerings. There's a specified offering, and then there's a fund. The specified offering is where you're raising money for something you have under contract right now. You have an exact roster of what you need to close on that deal, and that's what you're raising money for. A fund is where you're raising money not based on the property information that you're providing to investors. You're instead, in a fund, you're raising money based on your business plan that says, oh, here's the types of deals that we could buy, here's where we could buy them, here's what we're going to do with the money, and if we find things that meet this criteria, then we will buy them. So that's the difference. A fund is the hardest way to raise money. So just like Rule 506C, funds are not for people that don't have experience. Funds are for people that have built a track record and now have a sufficient experience with 5-6 deals, or have some really heavy hitters on their management team that really have experience in that market, and then you can do a fund. But most of our clients start with specified offerings. So we create this LLC for them that's called a manager managed LLC. And it usually has two classes of members. Class A are your investor class, including you if you're going to leave your own money in the deal. And so your own money in the deal could come from your own cash investment, or it could come from not collecting an acquisition fee and maybe turning that into a Class A investment alongside your investors. Maybe not getting reimbursed for your pre-closing expenses and just leaving it in the deal, then you'd use that to buy Class A interests right alongside your other investors. Class B is the portion of the deal that you've carved out for the management team. So very typical right now are 70-30 deals. So 70% goes to the Class A investors. You sell them 70% of your company for 100% of the cash that you need to close the deal. And then you save 30% of that company for the management team. And those become the Class B members. So this manager managed LLC, so there's really two LLCs here. There's the LLC that's going to collect the money from investors. That's called, according to the SEC, the issuer of the securities. That's the one that's selling the interest. And then this manager of it is a separate LLC, and that's going to look maybe more like this joint venture where you have multiple, 2-3 members, no more than 5, putting together this deal and raising the money. Okay, so who earns what? So the manager earns manager's fees, a share of cash flow, and a share of the sales proceeds. What do investors get? They get a share of the cash flow and a share of the sales proceeds. And so what kind of fees can the manager earn? Acquisition fee, it's usually 1 to 3% of the purchase price. An asset management fee, 1 to 2% of the gross collected income. A refinance fee, 1 to 2% of the loan amount. A disposition fee, 1 to 3% of the sales price. And then there's distribution. So the manager or the manager, so the management team, remember, earns the Class B interests. And so if you go back over here, this Class B sweat equity, this is where your management team earns its share of the profits. All right, so that's where you would earn your share of the cash flow and your share of the sales proceeds. So let's talk quickly about how to legally market your offering. So first of all, let's think about what's in a securities offering. So I've talked about an offering package or offering documents. So these are what they are. So you have a private placement memorandum. This is that disclosure document that is designed to give the investors all the material facts they need to make informed consent. So that is the disclosure document. And then you're going to have some kind of an agreement with your investors that operates. It dictates how you're going to operate the company. So it's called the governing document for your company. So you can have an operating agreement if it's a limited liability company, or if you have a limited partnership, it could be a limited partnership agreement, but you're going to have one of those. And then you have a subscription agreement. So this subscription agreement is where the investor fills this out and they certify to you that they meet the financial qualifications for the offering. So you've described to them what those are. That they understand the risks, because in that PPM, there's about 7 pages of risks and all the different things that could go wrong that could cause them to lose all or part of their money or be taxed differently or something like that. So they also will certify to you that they can afford to lose the money. They understand the risks. They've got all the legal advice or tax advice they thought they needed, or financial advice, and they're going to go ahead and invest anyway. So that's the subscription agreement. That's there's the investor certifications to you. The investment summary. So we don't like to embed your business model directly in the PPM, because that's going to bore your investors to death when they have to read through 70 pages of a PPM to figure out what you're doing. So we like to have a standalone document that can explain to the investors the actual investment in layman's terms as a marketing piece. And so that investment summary, if you're doing a specified offering, is going to explain your property. It's going to talk about, you're going to show pictures of the property. You're going to talk about where it is, what the opportunity is, what's around it in the surrounding area, what your plan for that property is. And then you're going to show 3 very important financials to your investors. One is the sources and uses of funds. Where's the money coming from to buy the property? How much is coming from investors? How much from the lender? And then you're going to also explain how that money is going to be used. So your acquisition fee, closing costs, down payment, renovation costs, operating capital and reserves, legal fees. So those are very common things you'd see in sources and uses of funds. Then you're going to show your pro forma, your 5-year projections for the project, and how you're going to, the income and expenses that you anticipate, and how that's going to gel out over the next 5 to 7 years that you plan to own the property. And then the third thing you're going to show is your proposed exit strategy. So you're going to imagine into the future, all right, if we sell this property at the same cap rate we bought it, then after we've made all these improvements and we've improved the net operating income, this is what we think it could be worth. And if that were to happen, then here's how much we'd be able to share with the investors. So in your pro forma, you're going to show the investors, all right, of this cash flow that's left after we've been, paid all our operating expenses and our debt service, this is how much you investors get. This is how much the management team gets. You're going to show them that. And then in the exit strategy, you're going to also show how is that equity that was generated from the sale going to be split between Class A and Class B. And then what does that translate into as far as an overall annualized return? So those are extremely important concepts that you're going to want to get some training on if you're not familiar with those terms. And then there's the securities notice. Okay. So what do you need the money for? I think you guys are pretty well aware of this, but this is the kind of expenses that you would list in your sources and uses of funds. So how are you going to market your offering? You're going to have to determine which of these exemptions you're going to follow. And if you're going to do the Rule 506B offering that allows you to bring in non-accredited but sophisticated investors, then you're going to have to market then you're going to probably be approaching your family, friends, and acquaintances, people that you've already established those pre-existing relationships with. Or you could do the Regulation D Rule 506C, and you could freely advertise. You could put your offering on a website. You can, drop flyers from a plane if you wanted to. You can advertise any way you want, as long as your ads are not misleading or fraudulent. A lot of people use illegal capital raisers, and you've got to be extremely careful about people who call themselves capital raisers, because the only people that can technically sell securities are people who have securities licenses. So I'm going to just talk about how these exemptions are. These exemptions apply to the issuer of the securities. So that's the actual company that's going to be selling these interests to investors. And so it applies to the people that are within that offering. The members of that offering or of that company are the ones that can sell securities under this exemption without having a securities license. This is like a for sale by owner exemption, right? You're the owner of the securities, you can sell your own. But if you're going to sell for somebody else, that's when you need to have a securities license. Just like a real estate broker, like I could sell my neighbor's house if I wanted to for no money, but if I want to get compensated for it, I have to be a real estate broker. And I can sell my own house and it doesn't matter. I don't need a license to do that. So think of this the same way. You have to be part of the issuer of the securities in order to legally raise money for it. You cannot hire somebody to act as an unlicensed broker for you. You can't hire a third party unless they have a securities license. You also can't pay anybody any amount of money that's related to the amount of money that they've raised. And that doesn't matter if they're part of your issuer or they're not. Anybody, even your own employees, cannot receive bonuses based on the amount of money they've raised, because those are considered to be commissions. And so, if you're going to admit people to your management team that are going to help raise money for you, they have to have a job other than raising money, and that's what they're getting compensated for. The rule is that everybody in management needs to raise money or has a job of raising money, but nobody gets paid independently for that. So there has been some proposed rules. There was even in the Trump administration, there was a proposed finder's fee rule that would have allowed lay people to get commissions for referring accredited investors to deals, but it never got picked up by the Biden administration. So it's kind of dead in the water right now. And it's been proposed 3 or 4 times in the past. So it doesn't mean it can't come back. It's just not there now. If you want it, call your congressmen, call your senators, tell them, hey, pick this back up. We want this. Let them know that that's something you want. So you really, if you're going to be in the syndication business, if you're going to be raising money from investors because you want to scale your investing business, you're beyond what you can do by yourself, then you need an investor marketing plan. And your investor marketing plan needs to describe how you're going to meet investors. What are you going to say to them when you meet them? So that, your elevator pitch. How are you going to follow up with them? So you go to a big event and you collect 100 cards. Well, then what? You can't just go stick them in a drawer. You really have to have a plan on how you're going to follow up with them, what you're going to say to them during that call. And then you have to think about even beyond that call, and so during that call, what are you doing? You're trying to pre-qualify them, right? And develop that substantive relationship so that now you can start offering them deals. But then beyond that, that could happen and it could take you 6 months to get a deal. So how do you stay top of mind? How are you going to make a lasting impression? You're going to need some kind of a drip system or a newsletter or something to remind people who you are. And then what will you give your investors to take home if you meet face to face? So those are all things that you can get, marketing materials that you can create. We actually have a division called investormarketingmaterials.com that creates these kinds of marketing. We have an investor marketing plan, and then we also have marketing materials that we can create for you. But the kinds of things that you might need are a company brochure, a website, a property overview, pitch deck, all of these things that we are able to help you with. So how can we help you now? These are the kinds of things we do. We do securities offering documents. So we create your companies, we write the PPMs, the operating agreements, subscription agreements. We can work on joint ventures, whether it's you and 2 other people, or if it's you and you're a syndicate in a private equity company, you need representation if you're involved in private equity companies or joint venture partners. And we also have something we call a pre-syndication retainer, and that's for people who are starting out and they want access to us. They want to be able to ask us questions whenever they want, and we have that. It's a really nominal fee. It's just $1,000, but we also hold weekly masterminds for our pre-syndication clients. So I conduct those once a week, every Friday, and whoever is a client that wants to show up can show up. But check us out at syndicationattorneys.com. Do read that article in our library that's called How Do I Create a Substantive Relationship? And then do check out investormarketingmaterials.com. And if you want to get a free marketing plan template, you can do so at investormarketingmaterials.com, or you can email us. Read my book. It's helped a lot of people. It's gotten a lot of really great reviews. You can get a free digital copy of that at syndicationattorneys.com. Or you can buy it on Amazon. So that's it.
Thank you very much, Kim. It's a lot of information, a lot of golden nuggets there. If you can stop sharing the screen so that people, okay, great. I saw a couple of questions. And by the way, Nico put that article into the chat box, so you can just
perfect
there. Vian, why don't you unmute yourself and ask the question?
Okay. Kim, I was just wondering, let's say that I have a 506B deal and I would like to post on Facebook. Is that legal at all, or
no?
Or can I blast email to my, my friends, my family? Can I do that?
No, not on Facebook, because that's a public forum. You can, the whole point about a 506B is you're really supposed to be contacting people one-on-one.
One-on-one. Okay. So no Facebook. Okay. But if we have like a private group of friends, we can do that, right?
Well, if you had a very private group of friends and you've already established that pre-existing substantive relationship, then you could, but you can't, just because they're family doesn't mean you have the substantive relationship. You still have to ask those questions about their finances.
Yeah, absolutely. Okay. Got it.
Thank you. I think Vian also had this question. If it's a JV deal, can she put it on the Facebook?
You can, just make sure that it is a true JV deal, because I see a whole lot of people advertising for joint venture partners when what they really want are passive investors. And it's not what you call it, it's how all the members of the LLC behave that determines whether it truly was a joint venture or were you selling securities. So you have to make sure that you're asking for the right thing, and then you're only allowing people who will actively invest with you.
Understand.
Okay.
Thank you. Thank you.
Okay.
Jason Beck.
Yeah, my question was, I guess not while capital is being raised, but I guess afterwards, are there regulations around who's able to legally market that they have like an asset under management, or is that not a legal issue?
Well, so it is a legal issue if you're trying to do future 506B offerings, because the SEC considers past deals to be tombstone ads. And they believe that that's the first step in making an offer. And why would they care about what you did on the past deal unless you're priming them to make and to invest with you in a future deal? So if you're in the 506B world and you're planning to do 506B offerings in the future, then don't post financial information about your past deals. You can say, hey, we just closed on this deal. It's a fantastic deal. And, just don't talk about returns. Don't talk about investors. Just talk about the property itself.
Got it. Okay, thank you.
You're welcome.
Thanks. I see Senate has a question. Senate, you want to ask the question? Unmute yourself.
Kim, thank you so much for doing this. First of all, it was a lot of great information. So funny, weird scenario. You're on my call list for tomorrow.
Oh, wow.
So I need to talk to you about a specific deal that I need to do as a syndication. So I have a couple specific questions. How long does the process take to set something up, like as a syndication?
So
I call you tomorrow. How long until I'm done?
Yeah, well, first-time clients typically take 3 to 4 weeks to get offering documents from the time you engage us to the time you have documents in hand and you're ready to start raising money. So what we suggest for timing is that you hire us after you have a signed purchase agreement and you've reviewed the financials for the property, because we've actually done an analysis. And if you've done those two things before you engage us, you're 85% likely to close. It's, you should be having us draft the documents at the same time you're conducting the rest of your due diligence. So just, think about that as far as timing. Returning clients, the process gets a little faster. Sometimes, we can get them done in 2 or 3 weeks. But it's really just a matter of, getting in, getting in our queue, because we have 20, 25 clients running at a time.
Okay.
Mhm.
What does it typically cost to set up a syndication deal? I mean, I don't give an exact quote, but maybe give us a range.
Yeah, a typical range is anywhere from $9,000 to $15,000. $9,000 would be for a deal that was all accredited investors. But if you're a very typical deal where you're going to be raising money from private investors and including non-accredited investors, it's going to be around 13.5 right now. It's actually 15, but we have a first-time client special for 13.5. And then you should also be budgeting a couple $1,000, $2,000 or $3,000 in filing fees for forming your LLCs and for these blue sky filings.
Okay. And then one more question. I'm just going to take a lot of time here. Sorry. You covered that pre-syndication retainer program. I think that's a great thing. If you would just maybe touch a little more on that.
Oh, yeah, sure. Happy to talk to you about that. So it gives you up to 2 hours of one-on-one time, usually with me or with our other securities attorney. And then also we'll give you a free investor marketing plan template that you can fill out and create your own investor marketing plan. You get invited to our weekly masterminds that I hold every Friday. So it's really just kind of like, we go around the room, everybody introduces themselves. We all, try to figure out what questions people have and get them answered and try to encourage people to interact with each other. So those are pretty cool. We really like those. And we'll also give you $1,000 off your or more off your first syndicate with us. So.
This is great. How long is the term? Like, let's say you pay for it. How
It's technically 3 years, but I'll tell you, we're not, like once a client, always a client. You can show up at our meetings.
Okay.
So,
But I think it's a great way to get your feet wet and then see what's going on with before syndication.
it's a way for us to help nurture you from where you are, get you over your fears, make you comfortable that you're doing the right things, so that you can go out and syndicate deals.
Yeah, great. Thank you. Lens, why don't you mute yourself and ask a question?
Hey, everybody. Lance here. Thanks for gathering the group tonight. I had a question for you regarding a syndication deal. So let's say I have a friend of mine that's putting a syndication together, and I pool a couple investors, let's say raise 500K, and I get a piece of the acquisition fee, a piece of the carried interest, but I'm involved in management decisions, follow through the business plan, let's say reviewing financials, help with year-end tax prep work. So I do have a position on the management side. Is there any like legality issues around that?
No, you're doing it the exact right way. You have a job other than raising money, and that's what you should be getting compensated for. So as long as there's no formula in there that says, oh, and you raised $500,000, so you get this too, then you're okay.
I gotcha. Perfect. Thank you.
Yeah.
Thank you. I have one question.
Mhm.
I hear different views from different groups. So let's say as a syndicator, your GP, now you can offer, let's say 70 or 80% of the equity of that holding company to the passive investors, right? That's also from your slides. But I hear some GP saying they cannot do that. So some GP says you can't do that. Yes, you can take 20, 30% of the equity just because you're GP of the deal, and you can structure it that way. And I hear some GP said, no, you just get that promote of the split of cash flow.
Well, the promote is the split of cash flow. So I mean, you could have 1%. Your ownership interest can be disproportionate to the percentage of the cash that you receive. So you could have 1% of the interest, but be entitled to 30% of the cash flow. We just happen to write them so that you have the 30% ownership interest, which solidifies your right to the cash flow. So, you know,
So
there's a lot of different ways that they can be written, but yes.
So there's nothing wrong as a GP taking 20%, I mean, legal standpoint, 20% or 30% of the equity just by being a GP.
No. Well, we do have our clients pay something for their Class B interests. We usually have them pay $1,000, and that's so that they can establish a cost basis so that later on, when you sell the property, you could be taxed at capital gains rates.
I see. But in that sense, if, God forbid, but if there is a capital call situation, would GP be responsible for the?
Depends how your capital call provision is written. We only write voluntary capital calls into our documents. We used to have the onerous provisions that would penalize people if they didn't, perform. But what we've learned over the years is that most times, if someone can't contribute, it's because they can't, right? They're just not in a position to be able to do it. And other people will usually raise their hand and say, I'll do it. So we try to make it as easy as possible for our clients to get the money that they need without having to wrestle all the investors for it and then create ill will.
Gotcha. Okay. Thank you. Great.
And also, we also write them so only the Class A members have to make the capital call.
Capital calls. So it's basically depends on how you structure it from the beginning.
Yeah, you've got to be careful about what's in your documents, and you really need to read them and understand them so that you're not getting stuck in something that you or your investors aren't going to like later on. And our documents evolve constantly, and that's based on the real experiences of our clients. They'll come and say, look, this was really hard to do and we followed this, let's try to make it easier. And then we'll say, yeah, we should do that for everybody. So that's happened for us.
Thanks. I have Ralph raise a hand, right?
Yes, thank you so much for doing this, Kim. My question is about becoming an accredited investor. I would be a guy that basically would come down to net worth. So I have 6 single family apartments. Figure if I sold them all today, they're worth 1.5 million, something like that. What is the appraisal process? And I hear it's changing all the time. Like, is this something
you don't have to? No, you don't have to do an appraisal. You can use any. It's really between you and your CPA. However, you can use any commercially reasonable method for determining the value. So if you wanted to do an NOI calculation and ask a local broker what the current cap rate is, you could easily figure out what the property would sell for if it were to sell right now. And you could use that as your estimated net worth. it sounds to me like you're not going to have a problem.
Right. Okay. So it's actually not, and is that something that I have to have verified? You know, I know it's, you know, every year, do I have to verify that I'm an accredited investor on those properties?
So you're only verifying that you're accredited investor if you're going to invest in somebody else's Rule 506C offering.
Mhm.
And you would do that verification within 90 days of making that investment. And once you've invested with one issuer, one of the rules that changed last year is that that's now good for 5 years with that issuer. But if you wanted to go invest in somebody else's Rule 506C offering, you'd probably have to get a different verification from them. However, if you're using one of the commercial verification services out there, then you probably could just go back to them and say, hey, I'm going to invest in something else. Can you update this? And they might ask you for some information, but they're probably going to rely on, you know, a lot of what you provided before.
Okay, so it's not a process, you know, all the time repeating it and maybe facing some roadblocks there if the market changes, let's say.
No. You just have to, it's within 90 days of making the investment.
Gotcha. And my question is about pro formas and I guess what you've seen, you know, just like, you know, so what they advertise, let's say they hope, you know, they hope they can provide an 8% return. How have you seen, what's the accountability? I guess look, everybody's taking a risk, but what's the accountability of them claiming, yeah, we're expecting a 12% return? Is it just, it still boils down to the risk you're taking and, you know, their paperwork, or what is the accountability these days? And
So
how is that changing?
So when you invest in an LLC, the LLC is not allowed by law to make a distribution unless the company has actually generated the income. And so if the company generates the income, what that 8% preferred return says is that you're going to get 100% of that cash flow until you get to your 8% before the management takes its cut. And so that's, you know, so 100% of the cash flow could still fall short of 8%. But if it's a cumulative preferred return, then it would, let's say you only got 6% in the first year, well, then that 2% that you didn't get would carry forward. And then eventually when there's a refinance and some cash out or a sale, then the equity would be used to go back all the way to the beginning, make up any arrearages in that 8% for those early years. And then, you know, the rest would be split with between investors, Class A and Class B.
Right. So they essentially catch up. So there is kind of a way, that's sort of how they still can help guarantee or what they're claiming, you know, that they hope to provide. Thank you so much for doing this.
Yeah, there is another article at our website. You guys are asking really great questions. So there's another article on our website that everybody should read, and it's called Class B Catch-Up Distributions Explained. And the reason that I do that is because we strongly urge all of our clients to do Class B catch-ups. And what that means is that instead of just giving an 8% preferred return to your investors and then you taking 30% of whatever's left, you're instead splitting cash as if it was split 70-30 from the beginning. But if the 70% that you're giving to Class A is not sufficient to give them their 8% preferred return, then you'll give up a portion of your Class B earnings for that year to get them there. But you're keeping the right to catch that up later so that when you do that capital transaction and you do have that chunk of cash, you can go back and make it up so that it's equivalent 70-30 split all the way from day one. And that has a big impact for our clients, but not a very significant impact for their investors. So it's something that should be worth knowing.
Excellent questions, guys. And Kim, thank you so much. I want to be mindful of your time. There were a couple more questions, but Lance, do you have your last question regarding 506B, is it?
Yeah, question. So let's say you have your investor list, you have someone's PPM and you send it out to your core group of investors. That's fine for 506A or is it 506B? It's just you can't advertise online?
No, you can't. So your 506B offering can't be advertised to anybody. It really just is, you can solicit people that you've already established pre-existing substantive relationships with. So that if you're part of the issuer of those securities and you take that PPM and you want to send it to your pre-vetted list, then you can do that, but you can't put it on any kind of social media or anything like that. So
Understood.
general solicitation and advertising means things that are available to the general public. So posting it on your website, any kind of social media, putting an ad in the paper, all that would be general solicitation and advertising.
Gotcha. Last question. So what rights does an investor have? They invest in a deal. They feel like the business plan has been properly executed. They want to question the financials. They don't get their preferred return. Have you ever seen that with any syndicators you helped out with? Or is that extremely
Yeah,
uncommon?
no, that does happen. But what really should be happening is that the investor shouldn't have to question anything because it should have been provided to them from the beginning. So ideally, you should be providing quarterly financial statements to your investors and showing them what's happening at the property. And if you're keeping them informed all along, then that shouldn't occur. A lot of
Gotcha.
times what happens is syndicators get in over their heads, and their first instinct, once they know they're over their head, is to bury their head in the sand and stop answering phone calls, which is the absolute worst thing you could possibly do. Because then everybody freaks out and it's like, hey, I can't get a hold of this guy anymore. So they either think you're stealing the money and, but at the very least, if there's a problem at the site, okay, then you should be involving the investors and having a meeting with your investors, letting them talk, about what's happening. I had somebody who had a property get foreclosed on. There was some wind damage at the property. The estimated damage was $2 million, but the insurance company gave them $200,000. They couldn't get 2 buildings back online. And so in the meantime, they didn't have enough money to pay the mortgage. The mortgage started getting, foreclosed on. They did every single thing they possibly could to, get the insurance company to do the right thing, to forestall the mortgage, all of that. They started having weekly meetings with their investors. So if something's going wrong, step up your communications, maybe monthly, maybe even weekly. Just let them know, here's all the things we're doing here, and listen to them, because a lot of your investors are, smart business people who might have some great ideas that you hadn't thought of, or maybe even a way to help you out. So listen to what they say. You have the ultimate decision making, but if you give them a voice, you're a lot less likely to get sued or blamed.
Excellent.
Gotcha. Makes great sense. Last question. What if someone checks an accredited investor and they wind up not being one? What's the risk for the syndicator or the person bringing them in? Last question.
Well, so there's actually an article. It's interesting because this article is the most visited article on our website, and it's called "What Happens If I Lie About Being an Accredited Investor." So it just tickles me that everybody wants to know this, right? We write it into our documents that if you lie about it, it's your problem, and anything that results from it is your legal fees, right? So, you don't, in a 506B offering, you don't have an obligation to make a further inquiry unless you have actual knowledge that they're lying. All right. So, your roommate, says, hey, I'm just going to check the box, I'm an accredited investor. Well, if you're privy to that, that's a problem. But if it's, and I actually had somebody one time who said, I told these people this was an accredited only offering. I told them I wasn't accredited, that I only had $900,000 net worth. And they said, oh, that's okay. Go ahead and submit your subscription agreement anyway. They took his money. Then a few months later, he realized that the deal was going bad, and he called me and I helped him get his money back. Because I said, you never had the right to take his money in the first place. So they gave him his money. And unfortunately, the rest of the investors got scalped, but he did get his money back. So, he didn't lie about it. He was, just told go, and I looked at his subscription agreement and actually said, no, I don't have $1 million. They just overlooked it. So, you don't want to do that. And if it's a 506C offering, they actually have to go through a third-party verification, or they have to provide a letter from their own CPA, attorney, or registered investment advisor. I guess you don't have a way of knowing if that person's legit. And I don't think you have to do a background check to find out if they are, but if the person's making representations to you, you can rely on it.
Thank you.
Mm-hmm.
All right, great questions, guys. Really, really fun and really informative. Kim Lisa Taylor, you are awesome. I truly appreciate your time. Thank you so much. Again, really, we're using a lot of your time here. Joseph, do you want to say goodbye to everybody? And this recording will be sent out to everybody. We will send also all the links to Kim Lisa Taylor so you can get in touch with her as soon as possible. and connect with her.
Good. Thank you, everybody.
Bye. Yosef, you're muted. Bye, guys.
Bye.
All right, thank you. Bye.
We will have her information in email. We're gonna send out later. So thank you very much for coming and joining tonight. We learned a ton of good stuff. Thank you, everyone.
Thanks, guys.
Thank you. Thank you for coming. Thank you for coming. Whew. Let's start recording.